This case centers on a defendant who was already on felony probation when she was accused of committing another theft offense. What began as a routine sentencing hearing quickly turned into a critical test of accountability, credibility, and second chances. As body camera footage is introduced and the court reviews her prior opportunities for rehabilitation, the judge must decide whether probation can still be justified, or whether prison time is now unavoidable.
The court's Mr. Smith is prepared to prove that.
Okay, let's go through that.
The necessity for me to go into that.
All right, we'll go through that first. And it's my understanding, and we spoke earlier, kind of off the record, that the officer involved is unavailable, but that Mr. Smith has his body cam video footage from that date, and there's no objection to him putting that on as evidence in this hearing. Is that correct, Mr. Kimler?
Yes, Your Honor, that's correct. My understanding is due to the exigencies of the officer being involved in the shooting, he's on administrative leave and is unavailable to testify. I therefore don't have any objection to the body cam being played in his absence.
Thank you, Mr. Kimler. And just let me know when you're ready, Mr. Smith. And Ms. Lopez is here. Thank you, Ms. Lopez. And at the appropriate time, if you have anything to add as well, I'll give you an opportunity to do that. And so the allegation in count one that was not pled true to or not is the allegation of a new theft of property from July 31st of 2025 here in Jefferson County.
He's got to play the video.
I'm coming from the pocket side. 244 on the mirror.
And patrol 115 into E6 cars.
That's your scooter. Oh, I didn't know that.
Actors are going to the car, so I'm trying to leave out the
Hey, stop. You're being detained? Man in the back, please come up here. Hey, you're being detained, okay? Okay, we'll worry about that in a second. Just come over here so we can talk. Okay, so you're not under arrest, you're just detained. And so I thought she was detained right now.
She just took everything out and dumped it on the floor back there.
We're gonna
Put your hands behind your back.
wait for everything. And just stay here.
Do you have any other merchandise on your person?
Anything illegal? Underneath you?
They can take this. I gotta go back to school.
Yeah, we did. I watched you on the camera.
What?
I watched you on the entire time.
Okay. What we're doing, look, if you have anything illegal, look at me. Hey, just look at me. If you have anything that you didn't buy, just send it on the counter.
Can you text this out to me?
Not at the moment, no, because
I'm talking about.
Where you're acting, you're acting like a fool.
Oh, no, I'm not gonna do that to school. I promise I'm not.
just like so, just put it all right here. Nothing else in your pants or anything?
No.
All right, let me.
All right, any other evidence with regard to count one?
There is also the footage from the inside of the car where both are detained, where she actually speaks to the other defendant without the cops being there, and she talks about how she was here and you had told her not to do this anymore. But I think that first video kind of sums it.
This is the pivotal moment in the case. The defense challenges whether the evidence should be considered at all, arguing that the encounter amounted to an unlawful search. But the court focuses on a key distinction. The defendant was instructed to produce the items herself, rather than being physically searched by officers. That legal distinction ultimately shapes the judge's decision and dramatically changes the outcome of the probation hearing.
Any evidence with regard to count 1 before I make my finding?
Evidence, Your Honor, is in testimony.
And anything that could,
I'm looking at this trying to figure out if that's a legal search. I mean, she appears to be detained, so it's not a Terry search. It's a warrantless search, obviously. She's not under arrest and being searched at the jail.
they didn't search her. They said, if you have something, take it out. She took it out and she placed it on. They didn't even have to get to the search.
I guess she could have refused and remained silent.
But she didn't, and so,
Followed the direction. And there's
Yeah.
no Miranda issue since she wasn't
right.
arguably in custody. I don't have the argument. I will go ahead and object that that's an illegal search.
All right, that objection's overruled. I am going to find count 1 true. And so, let me see, I need to. Counts 2 and 3, she pled true to, so there's a finding of true. Count 2. Again, everyone's had an opportunity to review that pre-sentence report. Mr. Kemmler, you may make argument with regard to
Yes, Your
punishment.
Honor. At this stage now that the state has offered evidence as to count, as to be a new offense, and the court's found that to be true based on the evidence, I think that the recommendation comports with the state of the record. I would, again, defer to the probation department, but I think that they're seeming to indicate that the court is to keep her on probation, that she enter into the ISF program, cognitive track, and I would defer to that recommendation in lieu of revocation.
Mr.
Or proposal, I suppose. I don't know if it's that word.
With the pending charge of this theft, she's not eligible to go to ISF.
She's, if I may, she's set on that today. I can resolve that today in this.
No, it's pending in felony court
It's here,
Oh,
it's
is it?
mine.
Okay.
because of the prior
All right.
thefts.
All right.
She's done with misdemeanor
Right.
thefts.
We could resolve that perhaps today, Your Honor, if the court.
I mean, I'm, go ahead.
The
What would you-
state, I feel like we have given her every possible chance to rehabilitate, and she has not taken that. We would ask that she be revoked and given, based on the number of thefts committed, that she be revoked and sent to state jail for 2 years.
Ms. Lopez, do you have anything else to add to your updated
I'll put
report?
everything in my recommendation.
All right.
Do you want to address the judge?
Yes. I feel like I did, how can I say this? I feel like I can finish my probation off because of the simple fact, like, this is the longest I've ever been away from my kids besides when I did 8 months, but they was younger than me, and like, I was younger, and like, they understand what's going on. And I understand, and like me being away from my kids right now is really hard. Cause they be with my mama, and my mama had dementia. And she,
Stop. Stop with everybody else. Because I'm not going to make my decision today that your mom needs you because you weren't thinking about that day. So don't put that on me.
No, I'm-
That if I send you to prison, that I'm somehow going to be hurting your kids or hurting your mom. You've done that. You were on felony probation, and it sounds like if the other video was played, you knew exactly what was going to happen. If what Mr. Smith is saying is true, that y'all were in that car and you said, Judge West said, I better not do this again. And you did it again. It just makes me look like an idiot for giving you the opportunity in the first place. At some point, you have to stop. At some point, you have to stop. Anything else?
Judge, even based on what you told probation is, she wants to be reinstated on probation. She was just with the wrong person. The girl she was with already took probation. I
Right.
wasn't the one stealing.
Yeah,
So she
I made a
doesn't
note of that.
Accept responsibility.
How is this my responsibility?
You accept your responsibility now that we saw it on a video. You didn't accept your responsibility. You said you were with the wrong person. I'm gonna tell you like I tell everybody else. You are the wrong person. She was with the wrong person. Y'all were with the wrong, you're all, if you're in there doing it, you are the wrong person, right?
Yes, ma'am.
So you didn't take responsibility. You haven't taken responsibility. You were given this opportunity after having felonies and going to state jail for the same offense, and I gave you a probation, and I said, don't do it again. So at this time, I'm going to find again, count one, that there was sufficient evidence to find count one true, find it true, find that you pled true to counts 2 and 3, find sufficient evidence to revoke your probation, and at this time, revoke your probation, sentence you to a term of 15 months in the state jail prison. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. I'm going to,
I'll get the other one worked out today.
okay, I'll hold it while y'all do that, and then while I'm doing that, I need a, yeah, I'll hand you the trial court certification in just a minute after y'all do that on this case that shows this was not an agreement. You have some limited rights to appeal. If y'all want to go visit about the other one, I'll hold it. All right, go ahead, go back that way. To Sanders.
Yes, ma'am.
And will your client waive the formal reading of the indictment?
Sure, Your Honor.
Ms. Sanders, in cause number 25, DCCR 1351, you're charged with the state jail felony offense of theft of property with previous convictions, and that is from July 31st of 2025. The indictment alleges you were previously convicted of theft November 13th of 2017, and then again April 15th of 2019. And how do you plead to that charge?
Guilty.
Are you pleading guilty freely and voluntarily?
Yes, ma'am.
And because you did what they charged you with? I have some documents here on the tablet. I guess it's coming. The documents on the tablet that have your signature on them that the state's marked as exhibit number 1. Did you go over those documents with Mr. Kimler?
Yes, ma'am.
Do you fully understand them?
Yes, ma'am.
And do you understand if I follow the agreement that you've made with the district attorney that you'll be waiving or giving up any right to appeal?
Yes, ma'am.
And do you also understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law?
Yes, ma'am.
Why is it less than what I just
Because of
did?
back time, I think she has less back time in the new case.
All right.
So it lines up on the release date.
It's Christmas.
It's Christmas also.
We'll go with that. State tenders number 1.
No objection.
It's admitted. Is there any evidence that Ms. Sanders is not competent?
Well, there's none to my knowledge.
All right, ma'am, I'm going to find that you entered your plea of guilty freely and voluntarily. Find those prior counts true. Find sufficient evidence at this time to find you guilty, and at this time find you guilty of theft with prior convictions. Sentence you in accordance with your agreement to a term of 12 months in the state jail prison. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. It will run concurrently, which means that together at the same time with the other case. I've handed you the trial court certification that shows this was an agreement that I followed, and so you waived your right to appeal. I also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. Firearm is a legal term, and you should read the written admonishment I provided you to see what devices qualify as a firearm. If you have questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk with Mr. Kimler. And I want to make sure you understand, don't go do this time and get out, keep doing the same. Could have actually been stacked on top of the other case. I could have given you up to 24 months on one and then stacked the other. So you already know now, we're not playing games. You've got to stop, okay? All right. You go back with the
Your Honor, for the record, as part of the plea bargain, she's waiving appeal on F-22 39884. So
Okay.
waiving the appeal.
Thank you, Mr. Kimler. All right, you can go back with
The court ultimately revokes probation, finding that the defendant failed to take responsibility despite being given prior opportunities to avoid incarceration. She receives a 15-month state jail sentence, while the new theft case is resolved concurrently rather than consecutively, preventing additional prison time. The judge's final message is clear. Repeated violations while on probation can quickly transform a second chance into a final consequence.